Okay, this is the second of two video presentations on diminished responsibility. The first video presentation introduced you to the defence of diminished responsibility, which is a modified defence under the Criminal and Justice Act 2009. We looked at each of the key elements in the order that they require you to look at them. This video will now look at the effect of intoxication when the defendant is pleading diminished responsibility and is also intoxicated, and the principles that were established in 5 key cases. Now, they are in chronological order, and they show the development of each legal principle from Gittins to Dowd in 2012. So let's start where we did in the previous video. This is just a recap of some important key points. So there are 3 special and partial defences that reduce a murder charge down to a manslaughter charge. Diminished responsibility, loss of control are the 2 that we are going to be focusing on. And we only need to consider those 2 under the Coroners and Justice Act 2009, which introduced the new defence of loss of control and, as said earlier, modified the defence of diminished responsibility. 2 very important key points. If a special partial defence is successful, it doesn't result in an acquittal the way that a general defence does. It reduces a murder charge down to a manslaughter charge. Okay, so it's not a license to kill. The defendant will still have to serve time. It reduces their charge down, and it's a key bit of information because then a judge has the freedom to impose whatever sentence he or she will feel is suitable. Special defences are different to general defences in that they only apply to a murder conviction. Here is that definition of diminished responsibility again. Remember, I do require you to commit this to memory, and I will be testing you on it. And make sure that you say it fully in the way that you see on the screen right now. So under Section 2 of the Homicide Act 1957, as amended by Section 52 of the Coroners and Justice Act 2009, the defendant must prove that at the time of the killing, he or she was suffering from an abnormality of mental functioning which arose from a recognised medical condition. This will have substantially impaired the defendant's ability to do one of 3 things. They are either they do not understand the nature of their conduct, they're unable to form a rational judgment, or exercise self-restraint. And then finally, all of that provides an explanation for the defendant's acts and omissions in doing or being party to the killing. Here's that diagrammatical format of diminished responsibility. So you see the 4 elements here on the bottom line there. So we start off with an abnormality of mental functioning. And remember, use the Byrne case for this point. It's a recognised medical condition. It substantially impaired the defendant's ability to do one of those 3 things, and all of this provides an explanation for the conduct. And our recognised medical conditions are all of those. As you can see, I've sorted out the error from video 1. They're recognised medical conditions. And in this particular video presentation, I have now also inserted this one, which is alcohol dependency syndrome, wood being our leading case for that point. Okay, here is the diagram that you also saw in that first presentation. Just to remind you again, abnormality of mental functioning according to Byrne 1960. A state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. Those conditions can either be psychological or physical. They must be from a recognised medical condition though. Examples of psychological conditions being things like battered women's syndrome, paranoia, depressive illness, mental deficiency, bipolar, post-traumatic stress disorder. why don't you pause the video here and just remind yourself of some of the leading cases next to some of those conditions. Can you remember the leading case for battered women syndrome, for example, or paranoia, or post-traumatic stress disorder? And then physical conditions are things like epilepsy, sleep disorders and diabetes. Now, what do we mean by substantially impaired? In Lloyd 1967, this was held to be not something that's total. It doesn't have to be total, mustn't be something trivial or minimal either. And it's something in between for the jury to decide. And this was confirmed in the case of Brown in 2011. And what has got to be actually substantially impaired, and it's not all three things, it's one of those three things. Okay, so the defendant is substantially impaired in such a way that he or she cannot understand the nature of his or her conduct, is unable to form a rational judgment, is unable to exercise self-restraint. And remember, all of these will seek to provide an explanation for the defendant's acts. Okay, so key cases in terms of diminished responsibility and intoxication. And we're going to look at these in chronological order. Gittins 1984, Tandy 1989, Doshan 2003, Wood 2008 and Dowds 2012. Now, if you've already have these cases in your case log, then pause the video here and just remind yourself of the facts of each of those cases. It will actually help you reinforce what I'm going to run through next. But if you don't have all of those cases, you will have them by the end of this presentation. Let's start off with Gittins first. Now, the defendant had been in hospital for some time and was being treated for depression. I don't have it written there, and I ought to have, but he was also drunk. He came home for a visit where he strangled his wife to death and raped his 15-year-old daughter, and the defendant raised diminished responsibility, which was successful. Now, the Court of Appeal stated that the test should disregard the effects of any drink or drugs and only consider if the defendant's abnormality of mental functioning substantially impaired his or her responsibility. Okay, pause and look at that very carefully as you write it down. So you're to disregard the effects of any drink or drugs. This would be instruction to the jury. Disregard the effects of any drink or drugs and only consider if the abnormality of mental functioning substantially, and remember this means not minimal, not trivial, not total, impaired the defendant's responsibility. And it would be for one of those three things, remember. Tandy came after Gittins a few years later, 1989, and the defendant was an alcoholic who strangled her 11-year-old daughter after learning she had been sexually abused by the defendant's own partner. She had consumed almost an entire bottle of vodka and was suffering from an abnormality of mind at the time of the killing. She was unable to successfully plead diminished responsibility, and the Court of Appeal established the following legal principle. Drink is only capable of giving rise to this defence if it either causes brain damage, okay, so if it either causes brain damage or produces an irresistible craving so that consumption is involuntary. So if the first drink that she had taken had been through an involuntary need, in other words, a dependency, then she might have succeeded. However, she wasn't able to show this. When alcoholism is put forward as an illness, the defendant is suffering, the jury will have to decide if that first drink he or she took was voluntary or involuntary. Okay, and if it's involuntary, it's more likely to be an abnormality of mental functioning caused through a disease or an illness. Doshan was in 2003. Now, the defendant killed the victim, a Nicholas Davis. He killed him in a very frenzied and savage attack. He was suffering a depression following the death of his Aunt Sarah, with whom he had actually been physically involved. Now, he was drunk at the time and responded to a taunt by Nicholas Davis about his aunt. And the Supreme Court made it clear that the defendant had shown, in this case, that even without the drink, he had clearly been affected by the abnormality of mind he was suffering. Now, the Supreme Court also added, the defendant does not have to show that he would have killed even if he had not been intoxicated, because abnormality did not have to be the only cause of the killing. This is a very important legal point, okay? So the point made in Doshan is very current, okay? It's important that you understand it. So please pause as you write this down and look very carefully at the information on the screen. Make sure you understand it fully. So what we're saying here is that voluntary intoxication alone is not an abnormality. But if you're already suffering from an abnormality and then you get drunk and kill, the defence may be available, despite the fact that involuntary intoxication played a part in the killing. Now, personally, I do have to pause information like this and look through it a number of times and really allow it to sink in. Don't always expect that you're going to get the information straight off. Sometimes you actually do need to do that. So in a nutshell then, the intoxicant, so whether that's through alcohol or drugs, and the abnormality can each play a part in the killing, and the courts were acknowledging this in the case of Doshan. The key would be to show that the abnormality was, however, a substantial impairment. And this is a task for the jury. It's not an easy task, but one that they do have to undertake. Okay, Wood 2008. Now this case confirmed Doshan in that the defence of diminished responsibility would not fail just because the defendant had consumed alcohol voluntarily before the killing. Wood had been diagnosed with alcohol dependency syndrome. He fell asleep at a party and awoke to the victim trying to have oral sex with him. In a frenzied attack, he killed the victim by striking him 37 times with a meat cleaver. What I want to know is what he was doing with a meat cleaver at this party. Now, the jury were asked to consider whether the defendant's responsibility was substantially impaired because of the syndrome. Okay, so take this information in small segments. So the jury were asked to consider whether the defendant's responsibility was substantially impaired because of the syndrome, and Wood is the leading case regarding alcohol dependency syndrome. If there is in fact evidence of brain damage due to the ADS, then the jury may be more likely to conclude substantial impairment. However, unlike in Tandy, there is not an actual requirement the syndrome should have caused brain damage. Okay, so there are a number of points being made there. Can you separate them out? So they're asked to consider whether the defendant's responsibility was substantially impaired because of the syndrome itself. Wood is the leading case. If there's actually evidence of brain damage, the jury can conclude substantial impairment if they so wish. And unlike in Tandy, there isn't actually a requirement the syndrome should have caused brain damage. Again, sit with the information for a few moments. Write it out, think about it. Dowds came in 2012. Now here the defendant argued that acute intoxication was a recognised medical condition. His appeal failed. He and his partner both had a long history of alcohol abuse and violence. One night after a very heavy drinking session, he killed his partner in a knife attack and his plea was unsuccessful. The Court of Appeal ruled that the Coroners and Justice Act 2009 did not change the rule that voluntary intoxication was not capable by itself of establishing diminished responsibility. Okay, so as you write that information down, please make sure that you understand the point being made there. So voluntary intoxication alone is not an abnormality. And in summary then, we can say from the cases we've looked at so far, and the leading cases being Doshan and Wood, 1, if the defendant has a medical condition and is also drunk, so they've got a medical condition already, and they are also drunk, the jury should ignore the drink and just consider the medical condition. Okay, so was that medical condition, that abnormality of a substantial impairment which explained the killing, Doshan? And it's for the jury to decide whether there is sufficient abnormality. And then secondly, if the intoxication arises from the medical condition, okay, so it's due to the medical condition that the defendant is drinking, like alcohol dependency syndrome, the jury can also consider the drink, but they must ask whether it amounts to an abnormality. And the case that illustrates that point is Wood. Okay, so as in the previous video, summary of diminished responsibility in its overview. Abnormality of mental functioning means a mind so different from that of ordinary human beings that the reasonable man would deem it abnormal. Byrne, 1960. Substantially impaired, impairment need not be total but must be more than minimal. Lloyd, 1967, confirmed in the later case of Brown. 2011. The defendant's ability to do one of three things. Now remember, one of three things is substantially impaired, and those three things being to understand the nature of his conduct, to form a rational judgment, or to exercise self-control. And the abnormality of mental functioning provides an explanation for the defendant's acts. This is a causation issue, as the defendant would not have killed if not suffering from the medical condition. Okay, so applying what we've learnt, let's look at the following scenario. Stefan suffers from alcohol dependency syndrome and is seriously depressed. His wife tells him she cannot live with him anymore. He gets drunk and then kills her as she is about to leave. Does Stefan have a defence to his murder charge? I'd like you to pause the video here and think about each of those elements in turn, one by one, and apply them to this particular scenario. Once you've done that, then resume playing of this video to check your answer with the one that will follow. Okay, I hope you pause the video and are actually doing this and not waiting for me to just move on to the next segment. It's important that you do it, so make sure you do it now. Okay, I'm assuming that you did do that and you've been really studious, industrious students. Now take a look at, it's kind of a brief way to show you how to structure your answer in order based on that very short scenario. So Stefan suffers from ADS and is seriously depressed. His wife tells him she can't live with him anymore. He gets drunk and then kills her as she's about to leave. Taking our first element, Stefan is suffering from an abnormality of mental functioning under Section 52 of the Coroners and Justice Act 2009. His abnormality of mental functioning is caused by a medical condition. Element 2, medical evidence can show that ADS is a recognised medical condition. And here you may want to insert the case name of Wood. The jury would need to be convinced of this. Element 3, the abnormality substantially, not trivially, and not necessarily totally, as according to Lloyd 1967, as confirmed in Brown 2011, impaired Stefan's ability to do one of the following. 1. Understand the nature of his conduct. Could he truly have understood the nature of his conduct as he was suffering from ADS? And the drink definitely wouldn't have helped. Remember, with ADS, the defendant is drinking because of their illness, so it's connected. Could they have formed a rational judgment in those in that situation? Very unlikely. And 3, were they able to exercise self-control? And we need only to show one of those 3 things, but it's very likely we'd be able to show all 3 in this particular scenario. And then you would finish off with that final element. The abnormality of mental functioning must provide an explanation for Stefan's acts. This is a causation issue. It's clear that he would not have killed if he had not been suffering from the syndrome, and so this made a significant contribution to his actions. Okay, pause the video here and think very carefully about everything we've looked at. How do you feel about the information? It will require you to do a number of things, and here is the checklist that I want you to run through. Please make full notes from Diminished Responsibility video presentation 1. Make full notes from Diminished Responsibility and Intoxication, which is this video that you are watching currently. Add the cases from both presentations to your case log. And when I do a folder check, I will expect complete notes, not summaries, complete notes please, and evidence of further reading and your case logs. Okay, be patient with yourselves. Don't expect to get it all in one go. Okay, it does take an incremental approach, and you do have to learn it, and we're kind of stage by stage. Okay, thank you for running through this presentation. Please make sure that you do utilise these videos again to reinforce your knowledge both before the mock exams and in the early spring term in readiness for your final exams.